Now for the conclusion of 12 presumptions of law, legal and lawful, judicial and clerical notice. Part 5. 27. The judge and/or clerk of the court is not the executor in this matter, and the prosecutor is not the beneficiary. For this matter at hand, the private bar guild appoint the judge/clerk of the court as the magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the current matter. I am the only authorized representative of the trust in the role of beneficiary and administrator, guardian, and/or general executor in the matter of trust before the court. For our purposes here, I suggest you refer to the U.S. Supreme Court case Luther versus Borden, cited at 48 U.S. 1, 12, Lawyers Edition 581, from 1849, in which it was decided in pertinent part. Governments are but trustees acting under derived authority and have no power to delegate what was not delegated to them. But the people, as the original fountain, may take that power, may take away what they have delegated and entrust to whom they please. Since this matter concerns my trust, I hereby reject any claim that any agency or agents of government have any authority over the trust involved in this matter. The trust is in my name, so unless here and now the judge, clerk, or prosecutor can produce such documentation that I signed away my rights to the trust knowingly and willingly, after having been explained the depth and possible repercussions of such waiver, the corporate agents have no claim on the trust, and therefore no claim over me and my person. 28. Executor decentort. Defined as a person who without legal authority assumes control of a decedent's property as if he were executor. I choose to assert my right as executor and beneficiary of the trust, as well as my body, mind, and eternal soul, so it is clear to all who witness this action that I am clearly not an executor decentort. With the aforementioned being accepted as truth in law, I respectfully ask the judge if he intends to commit fraud and act as the executor decentort, on the condition he agrees not to commit such fraud. I accept his oath and indemnify him for any actions I demand he obey. 29. Furthermore, I challenge the claims of psychiatry and psychology as being anything other than pseudoscience, false and without proof of its claims. For a judge to order a psychiatric evaluation would be him practicing psychiatry or psychology without a license, not even a degree. Commentary. Double check, because some of these judges have gotten their degree in law and a degree in psychiatry or psychology. But you can make that statement, and if they correct you and that judge does have such a degree, then you simply retract the statement. Remember Platsky earlier? You can rewrite it without this section. To continue. 30. As it is presumed to be a private business meeting of the Bar Guild, you are guilty whether you plead guilty or not, plead not guilty. 3 choices. plead guilty or not plead, or plead not guilty. Therefore, unless you either have previously prepared an affidavit of truth and motion to dismiss with extreme prejudice onto the public record or call a demurrer, then the presumption is that you are guilty and the private bar can hold you until a bond is prepared to guarantee the amount of the guild wants to profit from you. 31. Due to the judge's public oath to defend and protect the Constitution of the United States, he must abide by decisions of the superior courts, which include State Supreme Court, Federal Appellate Courts, and the United States Supreme Court decisions. It is called stare decisis, which is Latin for previously decided. Article 4, relationship between the states, Section 1, full faith and credit clause, demands such. It is written, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribed in the manner in such acts, records, and proceedings shall be proved and the effect thereof. 32. Furthermore, judges cannot argue the court operates under city, county, or state statutes, and therefore federal laws or superior court decisions are not relevant because of the Supreme Court case Gibbons versus Ogden, 22 U.S. 1 from 1824, in which it was decided when a federal and state law are in conflict, the federal law is supreme. 33. I hereby claim my status as a natural man or woman, una persona propria sui juris, and my minor account, who has the following rights protected and guaranteed by treaties and constitutions, international laws, and my self-determinism. 34. I also put the court on judicial and clerical, legal, and lawful notice that I intend to exercise my right to gather evidence and record all proceedings with my private audio and video recording devices of my choice. I require the judge to honor and enforce my right to video record these proceedings of public interest on private or public property. End quote. Beginning at right to video. Pursuant to the following Supreme Court precedents: Fordyce versus City of Seattle, 9th Circuit Court, 1995. The First Amendment protects the right to film matters of public interest. And Smith versus Cumming, 11th Circuit Court, 2000. Policies and procedures set forth by the courthouse policies do not supersede the aforementioned federal case law. 35. Void where prohibited by law. 36. Thus concludes my testimony. 37. Thus concludes my legal and lawful judicial and clerical notice. Now make sure you see part 6, because I'm going to talk a lot about it and answer some questions that people have asked me throughout the years of using this. Even though this was recently revisited, it's about 3 years old. So thank you for your time. Good luck, and get a hold of me if you can. I'll be happy to answer your questions.